Hi, everyone. Welcome. We're just going to give a minute or two for people to get logged in. Okay. Hi, everyone. Welcome to our webinar, CILA and NILA's webinar, Litigation for Unaccompanied Children, Updates and Foundational Cases. This is the fourth in our series of this webinar series. My name is Vicki Giambra. I'm one of the managing attorneys at CILA. Just to give you a little bit of information, at CILA, we are based in Houston, Texas, but we have recently expanded our services to a national audience. We provide technical assistance regarding case-specific questions relating to children and youth with immigration cases. We have 4 national working groups and 2 Texas-specific working groups, and we also provide trainings and written resources. We host a platform featuring pro bono opportunities across the country and provide resources related to pro bono. And I would also like to introduce our speakers. We have Trina Real Muto, Kristin Macleod-Ball, and Rickerd, all from NILA. And now we have Trina, who's going to tell us a little bit about NILA.
Thanks, Vicki. Hi, everyone. It's nice to be here with you today. I just wanted to talk very briefly about NILA, what it is we do, and how we may, be able to assist you. And Vicki's going to talk a little bit more about our partnership. But NILA is a new immigrant rights organization. We started in 2020, and we're focused on 3 core areas. One of which is impact litigation, and you'll see some of our impact suits on your screen there. And we also have a new suit we've since filed that involves a challenge to the asylum clock. And then we have 2 programs that may be of interest. One is the strategic assistance program, where we provide one-on-one strategic assistance through our membership. But Vicki's going to talk about how we do that in partnership with CILA in just a sec. And we have a co-counseling program, which allows us to accept cases on a case-by-case basis and take them to federal court. And we have a variety of federal court cases that we will do, and there's a co-counsel agreement, and it sets forth expectations. And so just very briefly, those are our core programs. That's a little bit about NILA, and now I'll turn it back over to Vicki to talk about how we work in partnership with CILA.
Thanks, Trina. So the CILA and NILA partnership includes trainings and resources, and additionally technical assistance questions that are related to federal litigation and appeals and things like that can be submitted to CILA, and we forward them on to NILA for their help. Our CILA website is constantly updated and hosts a lot of helpful information. And you can also reach us for technical assistance, including for NILA, through our website and our technical assistance web form. So this is now our 2nd year of collaboration with NILA, and this series for this year kind of joins our series from last year of 12 webinars that are on a multitude of topics related to appellate and litigation practice. Some trainings like this one were offered live, and many others were recorded, but they are now all on our website at our appellate and litigation strategy page. And we have included on this slide some of the trainings that are currently posted on our website. So you can see we have covered many topics in this partnership so far. We will be hopefully continuing on for a 3rd year. So with that, I would like to go ahead and turn it over to NILA to begin the presentation.
Great. Thank you so much, Vicki. We're really happy to be here to talk to you all today about some decisions from a variety of courts from the past few months that may impact your work. since we have a bunch to talk about, let's jump right in. I'm going to start out by talking a bit about a recent decision in a case called Lucas R. versus Becerra, ordering a preliminary injunction that's going to take effect very soon, next week, I believe, dealing with policies that impact children in immigration custody. So taking a step back, Lucas R. is a case that was filed several years ago as a class action on behalf of minors in the Office of Refugee Resettlement Custody as unaccompanied immigrant children. And the case involved challenges to ORR policies and practices related to the placement, care, custody, and release of immigrant minors from ORR custody. There were a lot of claims under the TVPRA, the Rehabilitation Act, due process claims, seeking enforcement of the settlement agreement in Flores, which is a longstanding agreement on detention of immigrant children. So sort of addressing problems with sort of how children are detained from a variety of angles. And in the intervening years, some of the claims, specifically those about the Flores settlement, were dismissed, and the court certified 5 different classes of kids in ORR custody related to sort of different parts of the problems that we're tackling. Most relevant for us in terms of the preliminary injunction that we're going to talk about are 3 classes of kids that I'm going to go through. First is what the decision calls the step up class, and that is minors in ORR custody pursuant to the TVPRA or 6 U.S.C. 279, who are going to be placed in a restrictive facility, right? And that's a secure facility, a medium secure facility, or a residential treatment center, or who ORR continues to detain in a restrictive facility for more than 30 days, who don't get notice and an opportunity to be heard regarding the grounds for their placement in that restrictive facility. So this deals with kids who are detained in restrictive settings without the ability to argue that they should be held in a less restrictive environment. Next, there's what the decisions call the unfit custodian class, and that is, again, minors in ORR custody that ORR is refusing to release to parents or other available custodians within 30 days of submission of a complete family reunification packet, on the ground that the proposed custodian is or may be unfit to take custody. So here we're dealing with kids with potential sponsors, but ORR isn't or is not going to release them because of assessments regarding whether the custodian is fit to take custody. Finally, there's a legal representation class, and that is, again, minors in ORR custody who are natives of non-contiguous countries and to whom ORR is impeding or will impede legal assistance in legal matters or proceedings specifically related to their custody, placement, release, in ORR custody, or also due to certain administration of drugs, although that's less at issue in the preliminary injunction. So again, this one is kids who are having trouble accessing legal help sort of related to the fact that they're in ORR custody. So there were also 2 other classes certified in this case related to kids who are administered psychotropic medications without procedural safeguards and kids who are detained in restrictive facilities because of disabilities that they may have, but those aren't an issue in the preliminary injunction. Those are sort of part of other parts of the case that are still going forward. So sort of what happened in the Lucas R case is both sides moved for summary judgment on a number of claims, pretty complicated. And last March, the court granted in part and denied in part both the plaintiff's motion and the defendant's motion for summary judgment. And the parties began trying to work out a preliminary injunction that would enforce the rights recognized for plaintiffs in the summary judgment order while the rest of the case continues, right? Because there are a number of claims, including all of the claims for those 2 additional classes that sort of haven't been addressed by the court yet. And so that's still ongoing. Then in August, the court issued an order on that preliminary injunction, right? That's actually sort of taking into effect what the court decided in the motion for summary judgment, the partial motion for summary judgment order. That's what we're going to go into detail on here today. The preliminary injunction was issued at the end of August, but it's going to take effect 60 days from when the order came out, which is, I believe, October 29th. So that's quite soon. And it's going to remain in place until the entry of final judgment in the case. We're going to go through some of the specific protections that the preliminary injunction ordered as we're talking here today. But what I want to really recommend that you do if you have clients that are going to be impacted by this case is to read the practice advisory on the decision that the organizations litigating the case put out. So it's by the National Center for Youth Law, the University of California, Davis Clinic, and the Center for Human Rights and Constitutional Law. And you can, it's linked in the materials that Vicki sent out for today's webinar, but you can also find it just by Googling Lucas R practice advisory, and it's on the websites for those organizations. In any case, it has FAQs and sort of case examples of how these different protections can apply for kids. So take a look at that. Okay, so turning back to the preliminary injunction order, what does it require? First, on behalf of the Step Up class, and remember that's kids who are going into or staying in restricted facilities without the ability to challenge placement decisions, it has a number of requirements. So there are sort of existing standards for kids transfer to or placement in residential treatment centers, and it sort of makes clear that those also apply to out-of-network residential treatment centers, and the sort of specific standards that already were applying have to apply to the out-of-network centers as well. It also sets forth that when they're sort of determining whether there are sufficient grounds for stepping up or continuing to hold a minor in a restrictive placement, ORR actually has the burden of proving by clear and convincing evidence that there are sufficient grounds to do that. And sort of the evidence that supports that decision has to be recorded in a child's case file so that child or their attorney is going to be able to find out about that afterwards. When a child is stepped up into a restrictive placement, ORR also has to provide a number of forms of notice related to that. So there has to be a notice of placement to the child within 48 hours. And then again, every 30 days that they remain in placement, the notice has to include the reasons that they're in that placement, a summary of the evidence. It has to provide notice related to sort of the right to challenge that placement, how that would play out, the procedures for doing so, sort of rights that apply during the process. And instead of just handing the notice to a kid, a case manager is supposed to explain the notice in a language that the child understands. The notice also has to go to the child's attorney and legal guardian of record within 48 hours, although there are certain exceptions in terms of providing notice to the guardian about if you can't contact them or if there are child welfare reasons, or when the child is older, if the child doesn't wish for the notice to go to the legal guardian. So where notice isn't provided because of child welfare reasons, that also goes into the kid's case file. And importantly, upon request, a child who goes into restrictive placement has to be provided with a hearing before a placement review panel to contest the placement upon request. And so that hearing, that ability to contest the placement is also going to include the opportunity for them to present evidence. There are a lot of sort of policies related to these placement review panels, some of which already were existing, but they have to be made permanent and agency-wide. It sort of sets forth different protections that are supposed to apply in this process, right? That their counsel has a right to review evidence, that there's going to be access to the case file within a reasonable time so that they can prepare. You could make a written statement, call witnesses, cross-examine witnesses, and sort of timeframes for which the whole process has to play out. And also there's sort of a directive that where a child doesn't already have an attorney, ORR is going to try and request or work with a care program to seek that they do get legal assistance to sort of navigate that process. There are also automatic administrative reviews that apply to these restrictive placements at 30 days and 90 days, and sort of additional reviews from doctors for kids who are in residential treatment centers. So those are the set of placements just for one of the classes. The protections for one of the classes in the decision. So there's clearly a lot of stuff going on. Again, take a look at the practice advisory for more details. The next part of the decision relates to the unfit custodian class that I was mentioning earlier. That's again where the proposed sponsors are going to be turned down. And so the protections that are going to apply there, again, there's some sort of existing notice and appeal processes that ORR has been provided when it denies reunification specifically to parents or legal guardians. And now they're going to have to apply those same protections to other potential sponsors, specifically a set of immediate or close relatives who aren't sort of parents. And you can read the specifics of those pre-existing notice and appeal processes in the ORR policy guide, which is available online. In addition, there are sort of automatic review of pending family reunification applications, where those decisions have been pending for at least 90 days, and every 90 days thereafter to try and accelerate actually making decisions and getting kids out of custody. There are also a set of protections that apply where ORR is going to be denying, or our staff person has decided they're going to deny the family reunification application where the potential sponsor is a parent, legal guardian, or other immediate or close relative. And so there has to be review of those denials by a neutral decision maker. They have to be within either 10 or 14 days, depending upon the sort of category that the proposed sponsor falls into. And after the denial, again, and this is specifically where the proposed sponsor is a parent, guardian, immediate relative, or close relative, there has to be notice to the proposed sponsor that details the reasons for the denial, evidence, sort of what the appeal process is, and different procedural protections that apply to the appeal process. And the notice also has to go to the minor or the minor's attorney, a more limited notice that's specifically just about sort of the decision, the fact that the denial happened, and their right to look at the evidence that's related to it. If the sole reason for the denial is that the minor poses a danger to themselves or others, then they also get the same sort of expanded notice that goes to the potential sponsor. The order also sets out a lot of sort of procedural protection requirements for the appeals process, sort of notice of receipt of the appeal, timeframes in which they have to conduct the appeal process, legal representation, and no expense to the government, sort of rights that occur during the process. Again, they're all detailed in both the practice advisory and the order itself, so you should take a look. And then finally, there are several protections set forth specific to the legal representation class that sort of relate back to the procedural rights set out for the folks in the step up class and the denial of release class. So ORR has to serve notices of placement for minors placed in restricted placements on the minors' counsel within 48 hours after a step up. It has to automatically serve a new notice to counsel every 30 days that the minor remains in the placement. And ORR also has to allow access to counsel when a child wants to present evidence relating to the step ups or step downs in ORR placement, or related to the release or denial of release to a proposed sponsor. And additionally, there are sort of requirements about access to the minor's case file while the child is in custody. So that's not a particularly quick summary, but it is a summary of some of the many protections that are going to be going into effect on October 29th related to the Lucas Barr case. But again, for those of you who are going to sort of be dealing with this in the nitty-gritty in terms of your clients, take a look at the order itself, which is posted on the organization's websites, as well as the practice advisory from the National Center for Youth Law, UC Davis, and CHRCL. For now, though, I'm going to turn it over to Trina to talk about, on a completely different note, a decision about the venue for filing petitions for review that could be coming up in your cases. Okay, thanks.
Great. Thanks, Kristin. So we put this case on in the session, and this case has gotten a lot of attention. It came down in June of 2022, and there's been a lot of discussion and a lot of grappling with trying to understand it and what it means for clients and the impact that it has in being construed and misconstrued by immigration judges. So I want to just start by saying that this case is about the interpretation of the venue statute in the Immigration and Nationality Act, which is about where do you file your petition for review. But this case sort of overlaps with a different, in my opinion, distinct issue, which involves what circuit law applies to immigration proceedings when you're in immigration court. To me, that is the choice of law concept. It is the concept of what law applies in immigration proceedings. And so just by way of background, I would like to tell folks that, the Board of Immigration Appeals in a case called matter of RCR, it's a 28 INN decision 74, the BIA in 2020 drops a footnote and basically says that the circuit law that governs is the law where the case is docketed, the docketing location, and that, in that case was where the person was located. And, that's a published BIA decision, and, theoretically it's EOIR's position on what law the IJ should apply. And EOIR could, of course, issue a published decision on this. They could issue policy guidance on this. But that's what I'll say about that for now. And that is separate from, what I'm going to talk about, but there is some overlap. So the case I'm talking about is called Herrera-Alcala versus Garland. And it touches on an issue that, quite frankly, has been around since video conferencing started back in, gosh, I don't know, I'm going to date myself, a while ago. In this case, the individual was in Louisiana, which is in the Fifth Circuit, and the immigration judge was hearing the case from an immigration adjudication center in Virginia. And so there are 3 immigration adjudication centers out there, and that's where all these IJs come together. They are sitting in a building and they are hearing cases all over the United States. There are 2 of these centers in Virginia and 1 in Texas. So the person appears on video, the immigration judge conducts the hearing, and the person, the counsel in the case, files a petition for review. And an issue in the Fourth Circuit cases was that petition for review properly filed. Now the statute at 8 U.S.C. 1252b2 or INA section 242b2 simply says that the petition for review should be filed in the circuit where the IJ or the immigration judge completed proceedings. And so there's a lot of concern about what does completed proceedings mean, and it may mean different things to different courts of appeals. So, for example, the Fourth Circuit in this case said the statute, we're just going to look at the plain language, and it requires that you file the petition for review in the venue where the immigration judge was located. And since that case was, the immigration judge was in Virginia, the Fourth Circuit said that's within our jurisdiction, and we can exercise review of the BIA's decision in that case. And the court goes into rejecting some arguments that the proper venue would be in the Fifth Circuit where the person was located, and also rejects this idea of the proper venue being in the location of the administrative control court. And in that case, it was a court in Minnesota, which is in the Eighth Circuit. So this is what the Fourth Circuit's position is. And I think what that means for people who are in bad circuits, who are having an IJ within the adjudication center in the Fourth Circuit, it means that the Fourth Circuit under this decision would be amenable to hearing their petitions for review. And that may be good news to some people. If you're in the Fifth Circuit, for example, it's a very difficult circuit, and the Fourth Circuit tends to have a better asylum law. What does it do for you as a practitioner when you show up thinking that you're going to proceed under Fifth Circuit law, for example, and all of a sudden, you've got an IJ sitting in Virginia? Well, I mean, the BIA's choice of law policy, should apply. We're going to see how this shakes out. But it just means that you have the option to file the petition for review in the Fourth Circuit. The Herrera-Acala decision in your write-up cites to other circuit decisions. They are not the first to interpret the venue provision. And so it's really important that you look, if you're sitting in the 7th, the 3rd, the 8th, or the 10th circuits, that you look to see what your circuit has said in terms of how they're going to interpret the venue provision. The other case to look at just came down on October 12th, so very recently. It's a case out of the Second Circuit, and it's called Sarr versus Garland. That's 474 F3rd 783. And in that case, the Second Circuit said that the proper venue for the case was the Fifth Circuit, because that is where basically the person was located. And there was an IJ zooming in or videoing in from New York. But the Second Circuit took a different approach to this issue than the Fourth Circuit. And they said, no, the proper venue is where the person was located, where the hearing was docketed. And they sort of adopted a position that's sort of more consistent with EOIR's choice of law position. And my understanding is also the position that Oil argues. So in that case, the court, however, said, this case has been docketed for a really long time. We're deciding this case in the context of a stay motion. Right now, it would be more detrimental to transfer the case to the Fifth Circuit. So instead, we're going to keep the case, and the Second Circuit is going to hear the case. And it instructed the attorneys to point out differences in the opening briefs where the difference between the Second Circuit and Fifth Circuit law would make a difference on the issues, which I thought is really interesting. And it adds an additional burden to petitioner's counsel to have to point out those differences. But I think it's fair to say that the Second Circuit overall is going to be a better circuit for that petition for review than the Fifth Circuit. And so the fact that the Second Circuit kept the petition for review, even though they thought venue was proper in the Fifth Circuit, illustrates a point that I want to make about petitions for review and this venue provision, which is that venue is and has been interpreted by the majority of circuits as a claim processing rule, which means that if you don't file it in the correct venue, that's not the end of the story. That the courts have the ability to transfer it to what they deem to be the correct circuit, if doing so would serve the interests of justice. And so that's an important point to note. I think that this issue, there has been sessions about this and talks about this, and there's probably going to be additional trainings about this, but I think that this issue can seem overwhelming and be confusing, especially if you're showing up and the IJ is trying to tell you to apply different circuit law. You're going to have to ask for continuances. You're going to have to make objections. You're going to have to build a record in order to preserve arguments, and you may have to interlocutory appeal if what's happening in your case is not what's in the best interest to your client. And that's where I come down on this. I come down on this question and this issue and this overlap between choice of law and venue on there is no right answer, except the answer is whatever is best for your client. And sometimes ascertaining what that's best thing for your client is going to be is going to involve taking a look into the different circuit law, figuring out how you can preserve arguments if you get hit with, all of a sudden notice that your IJ is appearing from one of these adjudication centers. You have to assess, is the law better for my client or not as well? And there's a lot sort of to think through when you're deciding whether or not you're going to accept the choice of law or you're going to challenge it. And then again, when you're deciding where you're going to file your petition for review. And that is why I wanted to point out the strategic assistance program that we have with CILA. So if you're listening to this and you reach out to CILA, this might be an issue where we can sit down and we can talk about the facts of your case, what the issues are in your case, and try to connect you or look for resources on what the variations in the law is on these different points in different circuits, so that you can make a decision that is in the best interest of your clients. And I'm speaking to you people now in the 5th and the 8th and the 11th, where it's very difficult to win a petition for review. I think Herrera Alcala opens up a door for you if you happen to get an IJ appearing from an adjudication center in the 4th Circuit, and it is one that is probably means you might not be admitted to the 4th Circuit. You might not know what that process involves, but it might be in your client's best interest to not fight to argue the case as best you can, and to later file a petition for review to the 4th Circuit, because that circuit may give you a better chance than the circuit that you're in. Happy to answer questions about that through the CILA NILA program, and if we have time at the end, if people have questions. And I guess I will leave it at that and turn it over to the next speaker.
Hi, good afternoon, everyone. It's Rickerd here, and I have a couple of asylum cases to discuss. One from the 9th Circuit, which we'll start with, Shamsher Singh v. Garland, and one from the 5th Circuit, Naduzzi v. Garland. I think these cases are linked in part because, as you'll see, especially in the 5th Circuit case, it is often a little difficult to understand why a panel decides to publish a case. Some are very obvious in terms of new law, precedent being set for the first time, or an intervening Supreme Court case, but others tend to be, as your experience would show, difficult to determine why a particular petition for review ends up in a published opinion when a comparable one, perhaps presenting a deeper factual record or more complicated legal issues, ends up being unpublished. And we'll get back to that in the 5th Circuit discussion, but I wanted to start with it because it also applies to Shamsher Singh's case, because the 9th Circuit spends 43 pages on a discussion of a fairly intensive factual application of what is past persecution. And it really does that in part because there's a dissent that takes issue with the factual analysis, but also because, as another opinion a few months earlier had underscored, there's a big disagreement in the 9th Circuit and in other circuits, as the case law is canvassed in those two opinions, about whether the review by a circuit court of a past persecution determination is factual or legal. And that's really where the standard of review issue comes into play, because factual questions are deferred to under the substantial evidence standard, whereas legal questions end up being de novo review. And I think this is particularly salient after the recent Supreme Court decision last term in Patel, where not only for jurisdiction, but for analysis of mixed questions of law and fact, these determinations are going to be even more important, I think, in terms of classification of questions as factual, legal, or mixed. So as we start to discuss the facts and the panel opinion here, as well as a concurrence and a dissent, I think keeping in mind that what looms behind this opinion and what was in May Fawn v. Garland, even more lengthy analysis of this question, may have led to the publication decision. So I think what also stands out in terms of this precedent and its future usefulness is that it's a very clear and more expansive discussion than certainly one would see in an unpublished disposition, but also draws very carefully on past cases to isolate at a level of abstraction what factual circumstances dictate a past persecution determination by the court, or at least one determining that the agency erred in not finding past persecution. So Mr. Singh came to the US just before he turned 18. And one very salient factor is that he was following his brother who had fled a year earlier and suffered similar injuries due to attacks that they both described by Congress Party members. And Congress Party members were hostile to the Singhs because they supported the Akali Dalman Party in terms of Sikh independence in India. And there are 5 factors laid out by the panel that led it to determine under either standard of review. It, at least for the majority, doesn't think it's necessary in this case to decide whether substantial evidence or de novo review applies, because under either standard, they would have reversed the agency's determination. And the 5 factors are first, that Singh was forced to flee his home after being repeatedly assaulted, that multiple incidents occurred, one of which involved a death threat. Third, Singh was between the ages of 16 and 18 when the attacks occurred. Fourth, his brother, as I mentioned, also experienced this violence. And fifth, we have already recognized that non-party members have faced persistent threats in the region of India where Singh was twice attacked. And even after doing this 5-factor analysis, the panel goes on to mention that citations by the BIA for the contrary conclusion are in fact not correctly applied. And so the dissimilarities are in part because of the conjunction of physical violence and a death threat, the multiple nature of these incidents. For instance, the dissent in this case by Judge Akuta spends a lot of time discussing a case called Hoxha, but in Hoxha, there was a single incident, whereas here there was a continuing interest, as the panel describes it, in Singh. And finally, it really applies to precedents called Aden and Flores Molina in the Ninth Circuit to boil everything down into a same or similar scenario, which the panel majority describes as a petitioner targeted for his political views, threatened, including a death threat, assaulted, leaving physical wounds, and compelled to flee his home. And a lot of this discussion has been factual and based on the record, of course, but I think implicit in the conclusion is also that the BIA made a category error, a legal one, in requiring serious injury to find past persecution. The BIA's decision in this case focused on a doctor who treated Singh after the second incident that he testified to, because the doctor reported only, quote, small bruises, scratches, blue marks, and some part of swollen body. The panel very clearly rejects the idea that there's a requirement of severe injuries to meet the serious harm prong of the past persecution analysis. And so I think in terms of the larger question, which may lead to either en banc consideration or get the Supreme Court's attention because of all this discussion in Ninth Circuit and other opinions, is what is a past persecution determination by the agency? Is it a factual one? Is it a legal one, a mixed one? The dissent isn't really about that. In this case, there's much more discussion, as I mentioned, in the Fawn decision in May. But what the dissent by Judge Akuta clearly makes its standard of review is substantial evidence going right to Elias Zacharias and really saying, look, the Supreme Court told us what to do, whatever precedents may be in tension in the Ninth Circuit, I'm going to review this under substantial evidence and factual findings. And so what really stands out is that there's a complexity, and this is best described in Fawn by Judge Collins, who concurs there, in determining whether the factual findings of the IJ, which of course the board has to review for clear error, are really what is being taken up to the circuit as opposed to the ultimate legal determination of past persecution. And I think there's nuance in Fawn where Judge Graber writes, drawing on Supreme Court law about judicial review, that she thinks, and this also comes up in some of the other circuit analysis, that there can be different presentations of a past persecution issue. Certain cases can bring it forward on a factual basis, and other cases can bring it forward on a legal basis. Judge Collins doesn't take an ultimate position in Fawn as to what he thinks the standard of review should be. And in a way, he's played a bit of an honest broker role in a couple of very important immigration review issues, one of which went en banc in a case called Alam v. Garland, which checked the Ninth Circuit's longstanding rule that if an adverse credibility determination is made by the agency on multiple grounds, only one of those grounds needs to be upheld to uphold the entire determination. And Judge Collins wrote that he was skeptical of this because, as one does in regular life, if you have 4 reasons to doubt someone and 3 of them are not determined to either hold water or meet the standard, then it casts doubt on the entire determination. So he successfully, in that circumstance, got the circuit to overturn that rule. And here he also is saying, look, we have inconsistency, and he implies that his leanings, at least, are toward this being a legal question. And I'll just finish on this by quoting a little from Fawn. He goes very much into the INA section 242B4B, talking about factual findings. And he says, treating the question here, namely the past persecution determination as a factual finding, would effectively require us to say that what is concededly a question of law in the BIA somehow transmogrifies into a question of fact when the case leaves the BIA and comes before our court. So ultimately, the BIA is making a legal determination based on its review deferentially to the IJ's factual determinations, whether it satisfies the legal standard. And then I think what Judge Collins is saying here is there's an analogous situation for the circuit court in relationship to the agency. And so he says, treating these as factual findings does not make much sense. And moreover, the dissonance is all the more striking given that the courts of appeals are sometimes called upon to uphold and enforce the BIA's treatment of such questions as questions of law. And so clearly, some of the circuits have treated the level of persecution as ultimately a legal question that requires the de novo review. So I do think, given these 2 opinions, given Patel, given some of the need to have a more full appreciation of what a mixed question is and what different elements of issues raised in the circuit courts deserve as standards of review, that this is something to keep in mind. There is the dodge that the panel majority uses in Singh to say, in either standard of review, we would find the same infirmity in the agency determination. On the other hand, as deferential as the substantial evidence standard is, and that's what Judge Ikuda's dissent spends a lot of time discussing, it clearly is in the interest of the petitioner to have de novo review given to questions of law, and mixed questions, of course, are questions of law under the analysis of A2D and the understanding of the INA's categorization. So I think I'll stop there and just see if I should continue with the next asylum case or someone else will jump in. Yes, perfect. Thank you very much. And I think this is also fascinating from the perspective of windows into a particular circuit court's dynamics. Nduzi v. Garland was initially published as an opinion by the Fifth Circuit on July 20th. And I know that CILA reviewed it in a litigation update. And what happened 2 days later was a regular reissuance of an opinion that to me, didn't look at all substantively different. And when you compare the PDFs, all that changed was the typo correction of supports to supporters. So essentially, this was a technical fix, but it's a bit of a lesson, because if you don't issue an order, as you know, that explains what changes from one opinion to another, you may draw more attention unintentionally to the opinion having come out twice, and maybe draw a little more scrutiny. But I think the bigger point here is that last week, just as Trina had the recent decision, we found that on the 13th, there was another order in this case, and that order was far more significant because it depublished the opinion. And as we'll discuss, there's not a lot of difference in terms of the analysis or outcome, but of course, this means that it's not going to have precedential value in the same way. And I think what we circulated in the notes is just interesting. I won't get too far into it, but happy to discuss and get others' perspective, especially regular practitioners in the court, as to the criteria for publication. Fifth Circuit Rule 47.5 is the one that governs here, and it has 6 subclauses in terms of when publication is thought to be appropriate, and then a general catch-all. An opinion may also be published if it's accompanied by a concurring or dissenting opinion, or reverses the decision below, or affirms it upon different grounds. So a lot of elasticity, of course, leaving it to the panel, and really leaving it to a single judge who can object to a decision being unpublished and require the publication. In some courts, these local rules can differ, but also some courts will not issue lengthy unpublished decisions. Others issue very lengthy unpublished decisions that are indistinguishable from an opinion other than the designation itself. So let's get into the facts of the matter. And I think it'll be evident, at least from an outside perspective, what may have led to the depublication. So Ms. Mariana Nduzi is an Angolan from a region that has long been separatist called Cabinda. And a lot of the factual background here is impressively presented in the case from the opinions recounting, because it importantly includes a lot of corroboration. She was in attendance at an independence rally in 2016, and the core of her claim was that she was attacked afterward by 3 armed men in government uniforms who broke into her home and in front of her children beat and raped her, leading to a 3-day hospital stay. Here, it is an adverse credibility determination by the IJ, and the IJ based this mostly on a conclusion that she wasn't consistent about her membership in the separatist organization called FLEC. FLEC is Front for the Liberation of the Enclave of Cabinda. And the real comparison is between the credible fear interview and the immigration hearing. And the panel assumes that it is proper to introduce material from the CFI notes. It said it didn't need to decide whether they're generally admissible, because even if those notes were properly admitted here, they do not support the conclusions the agency drew from them. And the IJ went further than that, and the BIA narrowed the agency grounds, but the IJ also decided that the FLEC organization was terrorist, even though it wasn't designated that way by the US government. But it's interesting, the panel includes some mention of that, even though it's not before the court. And so the BIA affirmed the grounds for the adverse credibility determination, and that's what's overturned by the panel. And it's unanimous here. There's no dissent that might have led to the publication. And we'll see that the panel's statements maybe attracted some attention from off-panel judges just about their implications for other cases. And so what I think may have led to the depublication was a desire to avoid either en banc consideration or even an en banc vote in terms of these principles as they would apply in future. And I think it's pretty straightforward in terms of why the membership ground didn't meet the standard of substantial evidence here in the record. It didn't show enough inconsistency. In fact, the panel said that she had testified consistently with her statements in the CFI interview because there was some misunderstanding of what membership really entailed in the FLEC. And so, as in other areas of immigration law, membership can be an elastic concept. And as I said, the record was very extensive here. There was not only her partner's testimony that she wasn't a member, there was additional corroboration from a child support advocate on the scene, 2 experts on Cabinda and Angola and country conditions evidence. And there were important data points. For instance, the panel highlights a common Cabindan saying, we are all FLEC, you know, the idea that the ethnic group there would have a self-definition of being part of this independence movement. So the panel says, look, all that's left were 3 other grounds that weren't inconsistent actually. And here's the holding that might have attracted some attention. So only the IJ's opinion remains that Ndudzi's demeanor was, quote, agitated, including when, the panel points out, she was asked about being separated from her children for over a year. And so what the panel said was the Fifth Circuit has never upheld a demeanor finding of adverse credibility absent consideration of the corroborating evidence. And if we didn't know this was a Fifth Circuit opinion and read it as a Ninth Circuit opinion or something, I think it would not necessarily stand out. And in fact, Ninth and Seventh Circuit citations are included in some of the analysis, which again might have attracted some additional attention. But at this juncture, the panel puts in a footnote which doesn't really resound in Fifth Circuit opinions very much in its tone. It added an observation on, quote, the wealth of contemporary psychological research suggesting that subjective perception of a witness's demeanor is an unreliable indicator of the witness's veracity. This is completely not even dicta, it's just commentary and wouldn't necessarily have any binding effect in a future case. But again, you know, a casual reader coming at this from another direction might object or, you know, request an en banc pause to analyze the opinion further. And the panel said and later deleted this footnote in the depublished version that such deference to demeanor in general is perhaps unfounded. So when you combine the adverse credibility inconsistency analysis and the deference point, perhaps that makes the depublication more understandable. In the depublished version, there are some changes, some edits. The panel says, quote, perhaps in a retort to the idea that it had enormous implications for future cases. It says this is a rare case with limited application to other factual scenarios. That cuts both ways, of course, because if it's very limited in its application, did it merit publication in the first place? Who knows how the panel determined that initially? And finally, I think as a practice matter, what's interesting in this very short analysis of the Convention Against Torture part of the case, there's this remand as well because of the principle that comes up often in cases with adverse credibility determinations, that the adverse credibility determination can't wash over the CAT claim. Often the agency will say, we didn't believe the respondent and therefore deny all relief. But there can be independent evidence, especially in a case where the record was built well, as appears here, that requires, even if some of the asylum claim is not believed an independent CAT analysis. And the panel notes here that that's especially salient because the CAT regulations require looking at the corroborating evidence explicitly, whereas that's just been something that case law has in the asylum context required as well. So I think I'll stop there. Thank you.
Great. Thank you very much, Chris. I'm going to jump back in and turn to a topic that we've discussed in previous. Oh, I don't have my video on. I'm so sorry. Here we go. Here I am again. Hello. So it's a topic that we've talked about some cases on this in previous case update webinars, and it's about sort of the exciting world of notices to appear and challenges to those NTAs that don't include all the information that is required by statute. And so I'm going to start with a little bit of sort of refresher background information that isn't in the specific cases we're going to talk about before we get into the BIA decisions and Fifth Circuit decision that I'm going to address here. So just to make sure we're all on the same page, right? As I think we all know, several years ago, the Supreme Court heard a case about the stop time rule for cancellation of removal. That's Pereira versus Sessions. And the stop time rule says that the time for continuous residence or presence in determining cancellation eligibility ends when someone is served with a notice to appear under 8 U.S.C. 1229A. So in deciding that case, the Supreme Court analyzed that statute, the notice to appear statute, and found that a notice to appear that does not include the time and place of a hearing is not a notice to appear under 1229A. And then more recently, the Supreme Court revisited similar issues in Chavez versus Garland, again in the context of the stop time rule for cancellation, determined that a hearing notice under 8 U.S.C. 1229A2 that sort of updates the respondent with the time and place information for their hearing doesn't cure a faulty NTA, right? The government needs to issue one document with all of the information that the NTA statute requires in order to have an NTA that complies with the statute. It's based on sort of a plain language reading of 8 U.S.C. 1229A. And that is important because since then, practitioners have sought to apply the Supreme Court's analysis of the NTA statute in a variety of other contexts, right? Because although Pereira and Chavez are about the stop time rule, that's not the only part of the broader immigration statutes or regulations that rely on or refer to NTAs and the NTA statute specifically. So we see discussion of those Supreme Court cases in cases obviously about cancellation and eligibility for cancellation, but also about similar requirements for voluntary departure eligibility, about cases about when immigration courts can issue in absentia orders. And I'm going to talk about one of those later. But most broadly, right, I think practitioners wanted to raise this sort of as a general starting point, right? Like any case in immigration court that's about 240 proceedings that started with an NTA should comply with the NTA statute. And so a lot of these cases initially tried to challenge immigration courts' jurisdiction over immigration proceedings generally. Where there isn't a complete NTA, you would argue that there's no jurisdiction because regulations say that immigration courts have jurisdiction when a charging document is filed, charging documents an NTA. Supreme Court said the NTA statute requires certain things. And so, an NTA that doesn't comply with the statute because it doesn't have time and place information should sort of cancel out the whole proceeding. However, and I want to be super, super clear about this argument has failed. It has failed repeatedly and in a wide variety of contexts. Before and after Chavez, at the BIA, at the courts of appeals that have considered it. So why am I talking about it? Well, a couple of recent BIA decisions sort of look at an alternative to this argument in terms of challenging an insufficient NTA filed in immigration court proceedings as sort of an initial step in those proceedings. The first of the cases that I'm going to talk about is Michfor, and it goes poorly. And then the second one is matter of Fernandez, which goes better. So this argument that we're talking about is the rules about NTAs including the, the statute that sets out what needs to be an NTA, are not jurisdictional. That's what the BIA and the courts have found, which means that they don't cause the immigration courts to lose authority to hear a case if they aren't followed. But there's still rules, right? You still have to follow them. The government still has to follow them. So what is a non-jurisdictional rule? Well, there's a whole category of procedural rules referred to as non-jurisdictional claim processing rules, essentially procedural rules that ensure cases orderly progress through an adjudicator. And though claim processing rules don't eliminate jurisdiction where they aren't followed, they can still be mandatory. And so you can still object when the opposing party sort of just disregards a rule, like, for example, the statute requiring NTAs to include time and place information. And so an important distinction about claim processing rules is that unlike jurisdictional rules, they are subject to exceptions and they can be waived or forfeited. So it matters when you bring up the fact that a claim processing rule hasn't been followed. And that's what these two BIA cases that I'm going to talk about address. So in matter of Mutafore is a little bit older. It's from early this summer, and it involved a motion to reopen a removal order. The motion to reopen was filed on the basis that the NTA in the case did not include the time and date of hearing. To get to the end, the motion was denied, right? The BIA decided that the regulations involving NTAs are non-jurisdictional claim processing rules. That's what I was talking about before. And therefore, an individual's right to object to the fact that DHS didn't follow the rule here, it didn't include the time and date information on the NTA, it can be forfeited. If the person who's objecting to the, what happened waits too long to say, hey, this is a problem. The BIA decided that by waiting until removal proceedings were already complete and raising the issue only in a motion to reopen, that's what had happened. The person had waited too long. So regardless of whether DHS messed up by not including the time and date information on the NTA, the motion was still denied because Mr. Mutafore had forfeited his right to make that challenge essentially by waiting until, year after the fact and filing a motion to reopen. So, that is what it is. So if you have this old case that doesn't have a proper NTA and you thought, oh, I'll file a motion to reopen on this basis, BIA is saying, don't do that, even though it's, claim processing rule, jurisdictional rule doesn't matter, just too late, you shouldn't do it. So not great news. However, there is a more recent decision by the BIA that does sort of explain how it wants you to make this sort of challenge instead. And that newer decision is in a case called Matter of Fernandez, and it involves someone in the same initial situation, right? He got an NTA that didn't include the time or date of his removal hearing, and then he later got a hearing notice with that information. Went to several master calendar hearings, he got an attorney, and when he was asked to plead to the charges on the NTA, he did not concede proper service of the NTA, and his attorney subsequently submitted a motion seeking termination of proceedings on this basis. Was denied. The case eventually went to the BIA on direct appeal, and the BIA found that the NTA requirements in the statute, that's 8 U.S.C. 1229A1, are non-jurisdictional claim processing rules, right? That's sort of the same thing that the BIA said in the previous decision, although that one was talking about the regs. Here, though, Mr. Fernandez raised the problem with the NTA much earlier in the process, right? And the BIA agreed that it had to sort of consider the merits of his argument because he hadn't waited so long. So the BIA found that DHS didn't comply with the statute, it violated that claim processing rule, and so it didn't comply with the statute by not providing a complete NTA to start proceedings. And the BIA found that generally to make an objection to this sort of mistake timely, generally should happen before the close of pleadings in immigration court. So quite early, you have to notice and make the objection early. Although I think the government was arguing that you should do it as soon as you actually receive the NTA. So better than it could have been, that's for sure. And then the BIA also found that additionally, in order to say hey, this is a problem, DHS needs to do something, you don't have to show that it caused prejudice to your client, right? Just the fact that they didn't obey this rule that's mandatory is enough to say, immigration court, you have to do something about this. So that's good news. However, bad news is the BIA didn't go as far as Mr. Hernandez was asking, right? They didn't say, oh, the immigration court should have terminated his proceedings. Instead, they remanded to the IJ for DHS to remedy the erroneous NTA, right? They don't have to sort of stop proceedings and then restart a whole new set of proceedings in order to fix the NTA problem. They said that the IJ in this case can allow DHS to remedy the defect in the NTA without ordering termination of removal proceedings. So the language is sort of says in this case, I don't think it rules out asking for termination in some other case, but that's not sort of the automatic remedy for fixing a faulty NTA. So what does that mean? If you're objecting to an NTA that doesn't comply with a statute in regular 240 proceedings, you should raise it as soon as possible before pleading to the charges on the NTA. But you have to know going in that it may not result in termination, right? It might just mean that DHS has to issue a new corrected NTA in the same proceedings. It'll sort of push back pleading and sort of the case's progress. And so you have to assess whether that's actually helpful for your client or not. But it does sort of show a way that you can object to the use of an NTA in proceedings that doesn't include the time and place information that the statute requires. One thing to note is that both of these BIA decisions sort of specifically flag Seventh Circuit law as different, right? Seventh Circuit had already addressed the NTA requirements as claim processing rules before these decisions came out. And so there's sort of potentially more helpful law in the Seventh Circuit that goes on a different path. It sort of says that you can seek termination specifically where DHS used an improper NTA on the basis that the agency violated this claim processing rule, the statute. And you could do it either by timely raising an objection or by showing good cause for untimeliness and that the bad NTA, the improper NTA caused prejudice. There's a few cases in the Seventh Circuit that sort of get at this issue. There's one called Ariola Ochoa, which is at 34 F 4th 603. And there's one called De La Rosa versus Garland at 2 F 4th 685. So if you have cases coming up in the Seventh Circuit, make sure that you look to the Seventh Circuit precedent rather than Fernandez when you're making these sorts of claims. Okay, so the last case that we're going to talk about in today's session is still about NTAs, but coming up in another context. Like I mentioned, there are sort of these Mies-Chavez-Pereira problems are coming up in a variety of contexts. And this one, Campos-Chavez versus Garland, which is a Fifth Circuit decision, deals with the insufficient NTA issue in the context of in absentia removal orders. So I'll start out by saying Campos-Chavez is a terrible decision. It's not great, it's not well reasoned, and it also limits the applicability of the Fifth Circuit's previous good decision in a case called Rodriguez versus Garland. Again, starting with a little bit of background, right? One of the statutes that refers to and relies on the NTA statute is 8 U.S.C. 1229A B5, which is the statute governing in absentia removal orders and motions to rescind in absentia orders. It provides that you can seek to rescind an in absentia order where you didn't receive notice provided under the NTA or the change of hearing notice statutes. And the Fifth Circuit previously found that the BIA erred in denying a motion to rescind an in absentia order based on lack of notice, where the person did not get an NTA that included time and place information because the person therefore hadn't received the notice required by the in absentia statute. And that decision was Rodriguez versus Garland, which is available at 15 F 4th 351. And it was later reaffirmed after the government sought rehearing en banc although with a dissent from a number of judges in the Fifth Circuit. So since the good decision in Rodriguez, the Fifth Circuit has sort of issued other decisions that narrow and push back against the ability to rescind in absentia removal orders based on getting a statutorily having had the proceedings started with a statutorily non-compliant NTA. One of the first ones was a case called Spagnuolo-Bustos, which we discussed in a previous webinar. The court found that essentially you give up your right to get proper notice and object to improper notice where you don't provide the government with contact information as required under the NTA statute. And so, your Rodriguez motion to rescind likely would be denied if your client didn't provide updated contact information before the in absentia order was issued in their case. Notably, that was tied to a specific requirement in the in absentia statute that sort of says individuals have to provide their address as required by the NTA statute in order to merit getting the notice that that is required for in absentia proceedings. So that at least had a statutory basis. In the case we're looking at today, Campos-Chavez, the court with very little reasoning decided that you also can't seek rescission for lack of notice under the Rodriguez reasoning, right? Which is to say, because your NTA didn't comply with the statute. If you subsequently received, or if you didn't argue that you did not receive a change of hearing notice with the time and place of your hearing. Essentially, the court said that because Spagnuolo-Bustos found you can't succeed on a lack of notice rescission motion if you don't follow the address updating requirements, then logically you necessarily can't do the lack of notice motion based on Rodriguez if you got a hearing notice. That's strange because Rodriguez itself involved somebody who got a subsequent hearing notice, but the language and the language of the statute doesn't provide that same sort of hook that the Spagnuolo-Bustos court relied on. But we don't really know why the court did that because it didn't analyze the language of the statute. It didn't analyze Chavez or Pereira. It didn't note that Spagnuolo-Bustos was based on a statutory interpretation. So in short, it's a bad decision. But it's published and it is binding. So there's been a rehearing petition filed. Government responded to it. We'll see if anything happens on that. But in the meantime, if you're seeking to rescind an in absentia order based on lack of notice tied to an argument that the NTA was deficient, be aware of this case. If there's any argument that your client did not actually receive subsequently issued hearing notice, be sure to include a declaration from your client to that effect, or other evidence that shows that, because that's sort of the flag that the court put in there. The problem was that the client didn't say, hey, I didn't receive this later hearing notice. More broadly, I want to flag that there have actually been just sort of a number of decisions and pending cases about the issue of no notice rescission of in absentia orders related to insufficient NTAs, right? There's Rodriguez in the Fifth Circuit, both the panel and the en banc decision, affirming the panel decision. In the Ninth Circuit, there's a case called Singh, which was also recently affirmed by an en banc court, although again, with a pretty aggressive dissent by many of the judges considering it en banc. The BIA has a case on this issue called Matter of La Para that goes the other way. It's a bad decision, although very long. And the respondent in La Para filed a petition for review, so it's pending before the First Circuit. There's a decision in the 11th Circuit in a case called De Costa Gomez, and that one is sort of in line with Matter of La Para. I think there's some other pending cases out there. So essentially, just be aware that this is an area of law that may be shifting going forward. And honestly, if you have a client that could benefit from any of the existing good law in this area, it may make sense to seek rescission sooner rather than later, even though there's no time limit on no notice rescission motions for in absentia orders, just given that we don't really know where the law is going to go on this. So on that ominous note, I think I will finish up and we can turn to questions if people have them. which I think that Vicki and Serena are going to facilitate for us.
Yes, absolutely. We do have a few questions. Let's possibly go back to the beginning. So the first one, in light of the decision in Lucas R, do you all have any practice points or tips of how to respond when a client is denied reunification with a close family member?
So honestly, if CILA folks have things that they want to jump in with here, you should definitely do that. I will say that the specifics of the Lucas R preliminary injunction have not even gone into effect yet. And so I don't think that there's any sort of practical experience about how the specific review process set forth there is going to work, or, you know, pressure points or that sort of stuff. It's set to take effect next week. So I'm sure that there'll be more guidance coming forward. And again, I'll highlight the practice advisory that sort of gives some case examples that sort of say, here's what might happen in various situations.
Great, thank you. Let's see. Going back to NIDUZI, considering unaccompanied children are not subject to CFIs, but DHS occasionally presents the I-213 to contradict testimony in immigration court, can we rely on NIDUZI v. Garland if the IJ makes an adverse credibility finding?
There's a lot in that question, and I think it echoes a future question as well. I think first, you're exactly right in terms of reliance. You know, just the fact that it was depublished doesn't mean that it's not citable anymore. And the reasoning can be helpful in other cases, even without precedential value. I do think that another thing to flag is that motions to publish can be an important factor for your future clients or our community more broadly, in terms of if a panel misses an opportunity to put something out there that would satisfy the publication rules, that can be something to point out afterward. All they can say is no. But getting to the heart of the question, I think NIDUZI itself tried to stay out of the lane of commenting generally on CFIs or equivalents. I'm thinking of airport interviews as well as the I-213s that you mentioned, but that can be something in other circumstances, and there are cases analyzing both on the agency's own requirements for some of these procedures not being followed and due process more generally not being followed in terms of the reliability of the information. But in this opinion, what they did and made very clear in terms of just a comparison of consistency among the CFI and the hearing testimony and the corroboration was that there was no inconsistency. So sort of accepting that the CFI is one point of comparison, even if you give it face value, it doesn't conflict with what she testified. But definitely welcome colleagues' thoughts on the CFI question as well.
I don't have more to add to that, except that just the problem in general of the CFI being the thing that, or sorry, the I-213 being the thing that DHS presents as and wants to be taken, you know, as true. I mean, there is an aggressive way of litigating removal defense cases, which is when you make your record to say, I'd like to bring in the maker of the I-213, I'd like to cross-examine the maker of the I-213. And when DHS refuses to bring that person in, or the IJ refuses to order it, I mean, I think you can use arguments there to say that, well, that document should not be given much weight, if any. I mean, our initial position would be no weight because they're refusing to make the person who made it available to testify. And then after that, very little weight. And there are some cases, I'm thinking of a case called Davila Bardalis out of the First Circuit that dealt with like information on an I-213 that was given by a minor in violation of regulations. Or I can't remember exact facts of that case, might be one to talk about in the future. But, you know, I would just sort of encourage people when they have an I-213 that has bogus information to challenge that, to preserve the record, and to keep raising that challenge to the BIA and to the Court of Appeals, and to look for that circuit case law.
Awesome, thank you. Okay, what is your view on the dissent's position in matter of Fernandez, that practically speaking, termination is the only viable option on remand?
Yeah, I mean, yeah, that's so essentially, right? The other option would be to, I guess, reissue a new NTA, but maintain the same proceedings and then plead to the new NTA. The fact of the matter is that, right, even if the proper remedy in a particular case is termination of proceedings, it's termination without prejudice. And so new proceedings can be begun sort of immediately by DHS filing a new NTA. And so, you know, I'm not sure how people are seeing this play out in sort of requests to correct an NTA after Fernandez. I haven't heard a ton about it yet, but you know, I think it's either, you know, you sort of repeat the same thing in a new proceeding, or you repeat the initial part of a proceeding going forward. But because Fernandez is directing you to make this objection at the very beginning of proceedings in general, the problems are going to be cases that were sort of pending in the pipeline, and would be going back on appeal after Fernandez, right? In most other cases, there's not going to be sort of a lot of the proceeding that has already occurred. You know, I don't have a lot more to say about that. I don't know if others do.
I mean, I just sort of will add on the termination remand option, to the extent that it seems like it feels like the right option to terminate proceedings, just as a remedy in general. It's often, as Kristin said, the possibility that they could, you know, institute new proceedings, sure, but what does that get the client? Is there any kind of work authorization that is attached to a pending application, or could be attached to a pending application? Does the client want to have termination and go out in limbo? I know that I'm dealing with this in another case where we're you know, advising the pro bono attorney, where we're sort of saying to the attorney in a different context where termination is on the table, or cancellation. And it really becomes a question of, well, what does the client want? And so just when we're thinking about termination and remand and all those, just to kind of keep in the forefront what makes the most sense in that individual client's case.
Awesome, thank you. I'm going to skip to a question that is after my own heart. For new attorneys, do any of today's panelists have any suggestions of references to better understand the difference between claim processing versus jurisdictional rules?
I'm laughing, Kristin is smiling. You know, this is an area that I think it's fair to say that Kristin and I both learned after reading lots and lots of cases and writing lots and lots of briefs on this particular topic. And so I don't think there's a law review article that we could just say, oh, read this and you're all set off the top of our heads. A lot of the times the more we are applying this concept, we started applying it in you know, the equitable tolling cases for motions to reopen. It comes up in tolling, it comes up in this issue that we're talking about, and the motion to reopen bar in reinstatement cases. We are seeing it pop up in a number of contexts. I will say that there are some briefs. This is something that we sort of talk to people about, and we direct them to certain cases in our strategic assistance that we provide to people. So I think we can kind of direct people to certain cases to the extent that we can, or to briefing that might be relevant. But it is a worthy endeavor to sort of look at some of the older Supreme Court cases, or the history of Supreme Court cases, and see how they get decided. And this is also an area where, because it's the Supreme Court that is really the authority on how you make this determination, what you have to look at is Supreme Court cases that are not immigration cases. Like there's a case called Henderson versus Shinseki that was written in the veterans context by Judge Ginsburg, I think in 2001 or 2011, I'm getting the date wrong, that sort of lays this out. And then there was every Supreme Court decision. There was one last term in a case called Vocler, which is a tax case about an appeal deadline. These cases, there's one up this term in a case called Arialiano or something. I'm spacing on the name. We're constantly seeing these cases. And so in order to sort of have the grasp of this and how it plays out, really have to look to the Supreme Court. Because they over the last decade have issued numerous decisions trying to get the courts to understand the distinction is different and how to make that determination. So I'm not sure if that's very helpful. Or Kristin, you have anything more to add? Or Chris?
Yeah, no, that's right. Essentially, the very shorthand is a rule is only jurisdictional if Congress made a clear statement that it was intended to be jurisdictional, and everything else largely is going to be treated as a claim processing rule. Look at the Supreme Court cases, and as a shorthand, look at the initial cases in your circuit, finding that the motion to reopen filing deadline is subject to equitable tolling, because those usually talk about jurisdiction. Yeah.
Just as a note, I think with all this, we had Jacob kindly say that they have seen 2 attempted NTA cures. DHS used an I-261, which the IJ rejected, and then DHS used pen and ink changes to the NTA, which the IJ accepted.
Well, that is quite something.
So I think we have time for at least one more question. What would you advise folks who want to raise a Fernandez-based claim processing violation, but whose pleadings have already closed through the removal proceedings, though the removal proceedings are ongoing?
I'm going to say it's going to be tough. It's going to be tough. So first of all, think about what you're getting for your client by doing that, right? It's, what the benefit necessarily is. But if there's a specific reason why it's helpful in this particular case, I think that you sort of look at Fernandez and say that this is how the timeliness assessment applied in this particular case. Here's the reason why my case is different, and why, we agree this is a claim processing rule, you have to raise it timely, but here's why it should be considered timely in this particular case. And I mean, you could also sort of look at some of the cases out there about where courts have found that there was a problem with pleading to the charges in the NTA, and you're able to sort of look back at that and sort of take it back and get another chance because the person was initially pro se, didn't understand what they were doing, there was ineffective assistance, there was something going on that made it sort of not follow the sort of usual course, which is you've pled to the charges, that's what you're stuck with, and that's what you do going forward. A little vague, but that's some possibilities.
Okay, thank you. One last question. I'm not sure we're going to have too much time, but I think it's a really interesting one. In Singh v. Garland, the court seemed to gloss over the fact that Singh was so young when he was attacked, between 16 to 18, only mentioning in passing that his age strengthens the conclusion that he experienced serious harm. Is it possible they didn't emphasize enough? And any practice pointers on how to adequately emphasize child-specific factors?
just to say that's an excellent point and may counterbalance some of my praise for the opinion laying out these 5 factors clearly. The passage that's relevant is extremely cursory and not at all commensurate to how important the Ninth Circuit considers age in these matters. It says the conclusion Singh experienced serious harm is strengthened by the fact that these attacks occurred between 16 and 18. With a citation to Hernandez-Ortiz, the key case, age can be a critical factor in the adjudication of asylum claims and may bear heavily on the question. And that isn't reflected in the panel's treatment or the Fourth Circuit en banc. There's much out there that would merit much more careful analysis. And just the 2 things to say are, yes, lay groundwork, of course, in the record, but also think of amicus support or, making the courts more aware of the importance of this, not only in their own pronouncements, but in the experts' views.
Great, thank you. We got some really good questions. I'm sorry we didn't have time to get to them all. But I just wanted to say thank you very much for joining us. We hope you can check out CILA's platform if you are interested in taking pro bono cases or if you're interested in posting pro bono cases. And you can join our newsletter that we send out monthly and always view our website for additional resources. And thank you very much for joining. Oh, I hope one of my colleagues has put in the CLE survey and our feedback survey in the chat. I can't see the chat right now. We do have CLE credit for this presentation, and we would appreciate your feedback. We do take all feedback into account and use it to kind of make our presentations better. So thank you very much for joining us.